Hey everyone, if you're here, you're probably wondering how to process a stock split for your company. So we wanted today to kind of go through that to talk about what a stock split looks like and what it means, and how we process one mechanically from the legal end. So for those of you who don't know me, that are tuning in perhaps for the first time, I'm Shawn McBride. I am a corporate lawyer. I'm licensed in multiple states. I began my practice in Delaware. Then I was in Texas for a while. Now I split between Texas and Florida, and yeah, I've been dealing with corporate issues for a lot of companies over the years. So a lot of my clients have different things pop up. One thing that pops up frequently is, at some point you need to redo your capital structure, and that means a stock split. Could mean a reverse stock split. A lot of the mechanics we're going to talk about today are similar between a forward stock split. That means you're taking one share and splitting it into multiple shares, versus a reverse stock split where you're decreasing the number of shares. And sometimes a reverse stock split is used if you need to squeeze some shareholders out. You can do something radical like 100 for 1. So that means anybody has less than 100 shares gets squeezed out of your capital structure. But today we'll be focusing primarily on the forward stock split, but a lot of what you learn will apply to a reverse stock split. So it's good material for you. I'll always remind folks I am an attorney, but just because I'm doing a video on YouTube doesn't make me your attorney. We're going to talk very generally about legal principles, a lot of nuanced things here. We'll focus on Delaware being one of the standard states of company formation. But every state has their own laws, and more importantly, every state has their own case law. So you want to understand that. You want to make sure you get an attorney that understands your situation and works through the paperwork. So we'll talk generally about what you need, but make sure you consult an attorney to get it all finalized and done. This will give you an idea as a manager what you might need to do. Your attorney will make sure you dot the I's and cross the T's. I'm going to go ahead and share my screen with you here so you can see a few things. We're going to go right into Delaware Code. I always like to show the authority, and those of you who see my other videos here, either on the McBride Attorneys Law Show YouTube channel or on my Future Done Right channel, which is kind of my flagship channel where we talk about the future of business. If you've been on either of my YouTube channels, you'll know that I like to research, and further, I like to show people where the research is coming from. Checking our sources is so critically important in this day and age because, of course, there is a lot of bad information out there. You're seeing my screen right now. I am looking at the Delaware Code directly from Delaware Gov. So we've got the law here. I've kind of already gone and looked. I know where we're going here. We're going to section 242. This is a little tricky, because you would think you would see something directly says stock splits, but that's not the case. There's a lot of case law out there that tells you section 242 is the place to go for a stock split. So we know we're in the right place here. Typically, it's almost always going to be the amendment of a certificate of incorporation after the payment of stock, right? So I don't see, you're not doing a stock split if you haven't issued your stock yet. There would be no reason to split shares if you don't have any outstanding shares. And to effectuate the stock split, you're going to amend your certificate of incorporation. So we're landing here on how to do it. The statute spells out the process, right? And it tells you when you need to do this, right? After you've received payment for your capital stocks. That's almost any company if you're up and running. If you're still in the formation stage, it may be different. But if you're up and running, you've issued stock, right? You've had your stockholders come in, you've got your board of directors, you've set your company up. So almost any moving forward company is going to be in the situation of after the payment of stock. Then we go back and we say, what are we going to do? What do we need to do, right? So we are talking about what can be amended. We could be changing our name. We could be changing the business, right? Because we have our authorization clause in our thing. Usually it's all lawful business, but there are times you want to limit the business powers of the company. We could be amending that. We could be, and this is the one that's going to be really relevant to us, increase or decrease the authorized capital stock, reclassify the same, change the number, par value, preferences, right? So we can do this, right? We're seeing right here statutory authority to change our stock around comes right from the statute. So we can do it, but and it includes increasing or decreasing number of shares or subdividing or combining the outstanding shares. So we're right here in clause 3, pretty clear. The important thing to think about too is not only do we need to do this forward stock split, we need to say 1 share becomes 2 shares, 1 share becomes 4 shares, or 1 share becomes 10 shares. We need to put that on record in our certificate of incorporation. But also, we need to think about the number of shares we have outstanding. Almost always, if we're doing a forward stock split, we're going to have to increase the authorized capital stock because we're doubling, tripling, whatever the case may be, whatever that multiplier effect is on the split. We're going to increase that. So we're going to have to go back and increase the authorized capital stock of the company. You can see some other things here that can be amended, amendments to the certificate of incorporation, and some things can be deleted, right? And here's the important part. We start getting down to 242B, and there's been some litigation over 242B in the Delaware courts, right? It tells us exactly how to do this. It's just very dense, the way it's spaced and worded. I guess if this statute had been written in more modern times, it'd probably be spaced out, but the Delaware General Corporation Law tends to have these long blocks of dense text, which makes it hard to read even for a lawyer, but particularly for a lay person. But we're going to go right into what are we doing here. So if the corporation has capital stock, its board of directors adopts a resolution setting forth the amendment proposed, right? So it's walking us right through it, right? So the board of directors adopt a resolution setting forth the proposed amendment. So we need a resolution from the board on the proposed amendment. They have to declare its advisability, and they either have to call a special meeting of stockholders in respect to vote thereon for consideration, or directing the amendment be considered at the next annual meeting of stockholders. So right now the statute's telling us. Now, it doesn't say it explicitly in here, but you also have the ability to do this by written stockholder consent. The case law has upheld that. That's in a different section of the Delaware General Corporation Law, so you can go over there and take a look at that. But it's pretty clear, right? The board has to approve it. They have to declare it's advisable, and then it has to go to the stockholders. And so, unless you have a specific provision in your certificate of incorporation, you can skip the stockholder step for changes in 1 and 7. And if you go back up above in A, you have changed the corporate name. Sometimes people do this when they merge a subsidiary in. They'll do a name change without stockholder approval. Can be done. It can also be done if you're taking out some stuff that really doesn't need to be in your certificate of incorporation anymore for any purpose, right? Who the initial board of directors are, or these other things. So there's a handful of ways we can avoid the stockholder consent, but generally we need the board consent and the stockholder consent. You have to notify the special meeting or annual meeting, of course. So if you're going to have a meeting, you got to do it the right way, and you got to tell the stockholders what the changes are. And so it has to say, hey, we're thinking about doing this change. This all makes sense because stockholders are going to vote on this, right? We need a real vote, and we need them to tell us. Of course, again, we can do this by written consent, but still, a stockholder should be informed of what they're consenting to or what they're agreeing to. And then you have to get the vote of the stockholders, etc., right? So very, very mechanical, but you got to do it in this way. And some people have tried to combine these steps or sidestep some of these steps, and the statute's pretty darn clear what you have to do, right? And then it talks about how the votes are processed, that you vote as class, etc. So you're going to follow your voting procedures set forth in your certificate of incorporation and in your other documents. So this is going to be processed how the stock runs. There's provisions for non-stock corporations, which it's not going to be happening as frequently. And so there we go. Pretty straightforward here, but it has to be done, and it has to be done right. And there's a couple of cases out there in Delaware where people have attempted to do this the wrong way, or they haven't followed the formalities, and they've been bitten by it. So make sure you follow it step by step. You've got the procedure there. Go to the statute, have your lawyer make sure they're following the statute, and it's pretty easy, right? So we follow the board approves the this proposed stock split, including the amendment to the certificate of incorporation, which the board should see. There's a case out there where the board didn't get to see the amendment till after they signed up for it. That's a problem. Board approves the amendment and then submits it to the stockholders. The stockholders approve it. Then after all of that's done, you file. So just follow the statute there. If you're a business owner, business leader, make sure you subscribe to the McBride Attorneys Law Show here on YouTube so you'll get more ideas of things that are going on in your business. Make sure you check the like button so other people can see this video and ring the bell for notifications because we're always trying to bring you the things you need. Drop a comment below. Let me know you saw the video. Let me know what you learned and what questions you might have. Of course, don't put any confidential information in there, and I can't answer your individual questions, but if you have particular topics of law that you're unclear about, I'm glad to do a general video that helps the public, but I can't address your specific situation because we're not doing attorney-client work here on the YouTube channel. That needs to be done on a confidential basis. All right, folks. Our Shawn signing off. Looking forward to seeing you soon, and I'm looking forward to seeing your comments below here at the McBride Attorneys Law Show on YouTube.